Good morning. The slide you see up behind me has the formal official title of what's generally known as the eIDAS regulation, which came into force in September this year. And my role in the team that manages this, which is known as the Legislative Task Force of DG Connect, is to provide advice and the practical content for how it happens. What you need to know, I'm sure most of you do, is that a regulation is all about the what, and then the implementing acts, which is like secondary legislation, is the how you do it. So we are working on the how you do it, having got the concepts and the policies agreed with member states over the last 2+ years. They were quite intensive negotiations to try to get something that worked for everybody. And at that time, I was negotiating on behalf of the UK. So, the eIDAS regulation, the bullet point at the top is, if you like, what it does, all of the regulation, because the regulation has a few chapters in it. It deals with electronic identification and trust services and e-documents. So I will have a few bullets on these slides about the trust services part, because I guess there might be a few people here who have some sort of interest in that, but I'm going to major on the electronic identification. So in a nutshell, it provides for the mutual recognition of electronic identity schemes supported by member states in a cross-border scenario. There's all sorts of conditions that are attached to that, and I'll touch on those as we go on. It provides electronic trust services, e-signature, digital certificates, timestamps, e-seals, and so on. Much of which builds on the previous 1999 Electronic Signature Directive, which I think is admitted by the Commission not to have worked too well, partly because there was too much flexibility in its transposition, which is what you do with a directive rather than have to enact it word for word as you do in a regulation. So it's kind of clarified the difference between qualified and non-qualified certificates and the attendant supervisory regimes. And the last bit, a very small chapter, I think with only 2 clauses in it, is the electronic documents. So key principles. On the electronic identification schemes, it's about mandatory recognition in the public domain. So if in one member state a public service is offered which requires, either by law or by administrative procedures, that online identification or services provided, they must accept an electronic identification means from another member state, provided that it's at the same or a higher level of assurance and it meets a number of requirements which enable that to be notified. So from that sense, it's asymmetric. Even if you don't notify your own scheme, say driving license or health or DWP, if you have an online system in your own member state where you accept an electronic identification means, whatever you do or don't do, you will be obliged to accept a notified electronic identification means from another member state. That's the gist of it. So we're very keen to ensure that it's understood that this is not harmonisation, this is interoperability. Most of the rules around the way it works is to do with what we call the interoperability framework and a cooperation network, which is bringing all the member states together to try to align what they do in terms of levels of assurance, so everybody knows that we have 3, high, substantial, low, which basically equate to 2, 3, and 4. So if somebody is notifying an electronic identification means and scheme, and they say, this is a high level scheme, you can be assured in other member states that it is indeed a high level scheme and not a low level scheme. And the way that is done is through a process called peer reviewing. But as I speak, these things are work in progress, and we have an expert working group, Adam and a colleague Robin Walker from the Cabinet Office are the UK representatives to that. But it's flexible in terms of you can nominate other people for specific tasks. The experts from all the member states meet together on at least a monthly basis and work through the issues of about how does one assure the identity through the identity proofing and vetting process, how does one manage credentials at the different levels, the authentication process, the lifetime cycle management, revocation, all of those issues. So that these are clearly set out in the implementing acts so that we can be clear when one maps a scheme against the core criteria, that everybody understands how to do that, and then there's transparency around it and so on. So that's the key to getting the public services in a mandatory fashion. Now, free of charge, this was an important principle that was discussed for quite some time. The authentication must be provided to the relying party, provided that relying party is a public service, free of charge. If nothing else, it avoids the problems around billing and so on, particularly in a cross-border scenario. And it's very easy when talking to forget to reinforce the fact that this is cross-border. There is no mandate, no legitimacy. We have this thing called subsidiarity. What member states do in their own country about their own electronic identification schemes is entirely down to them. But as soon as you cross into this cross-border scenario, the regulation kicks in. It doesn't deal with what you might call closed loop groups. It doesn't mandate for the private sector, but it does have a reference in, I think it's recital 17, to member states being encouraged to make available to the private sector the authentication means. In a sense, we would like to promote one electronic identification means, or as few as possible, across a whole range of services. The proliferation of eID means is probably not helpful from a customer point of view and might overcomplicate matters. So I think I've covered the key principles on eID. Just briefly on the trust services, I think one of the important things to say is that it will now be the case that anything done electronically in terms of signing will, through the regulation, have the same legal status in any court actions as a handwritten signature. And that's put that beyond doubt. And technological neutrality, we've very much gone for, well, in the trust services there's always been some flexibility, but also on the eID side we've gone for outcome-based measures. So how you do it, that's down to the member state. It's just you've got to hit the required outcome. However you do that is fine. Timelines, well, I've mentioned that it came into force in September this year. The implementing acts are in a number of time periods. The first one around member states cooperation was or is 6 months after September 2014, so in the spring of next year. That will formalise the way in which member states can cooperate to look at notified or pre-notified schemes that member states wish the Commission to publish, to work together in terms of learning and experience and all those usual sort of things. The two key points I'd like to bring out from this slide is that the voluntary part of this. In other words, if a country voluntarily wants to accept an electronic identification means from another member state, and you can notify that straight away. This could kick in on the 18th or 19th of September 2015. So we need to have in place by then the actual technical interoperability layer, which is being developed and will be implemented by another part of the European Commission known as DIGIT, which I'm sure most of you have heard of, through something called CEF, which is the Connecting Europe facility. So there will be an eIDAS interoperability system, and there's a technical subgroup of our expert working group, and again, Adam is the UK member on the technical subgroup looking at issues to do with point-to-point encryption, how one does the binding, and all those sorts of things. The mandatory part, there was lots of discussion about this during the passage of the regulation, and in the end it was settled on September 2018, which might seem a fair way into the future, but for some member states this is very much round the corner because they have no experience or history of electronic systems, or they're not engaged in STORC, which has enabled a number of member states to get hands-on experience and understanding of the issues arising from all of this. Okay, so I mentioned the private sector. We recognise that the public sector, in terms of cross-border activity, has limits. The bigger picture and the big gains from this are about cross-border use, growth in the economy, innovation and so on through the private sector. And we in the Commission want to work very closely with the private sector to drive this forward. Somebody mentioned earlier about a lead in the UK. Well, more broadly, we believe that the Europe has much to offer in terms of, or it needs to continue to keep its lead in some aspects of this. And we've done some work, stakeholder engagement with industry, and there is clearly a message coming across. We are not communicating very well that there is this regulation and what it does and how one can build on it, so we need to do better there. There is a demand from industry for a secure and trusted and simple to use cross-border system so that they can know who they're dealing with. We need to very much work on, we called it a business model in this slide. It's the difficult question of if the private sector is going to use a publicly or government provided authentication service, should they pay for it, and if so, how much? And of course that can be a different answer in all the member states because that's member state business. But how you deal with that in a cross-border scenario certainly needs to be tackled. And we very much have it in mind that, okay, we're talking about Europe today, but this is an EU federation, and we would like to look at federation with other jurisdictions and try to develop and encourage other jurisdictions to have not just a system that interoperates with this, but picks up some of the principles and key parts of this regulation. So we also have to work better, I think, in the Commission with other directorates because of regulatory alignment. In this event we had on November the 19th, we had a lot of sectors represented: banking, insurance, other financial services, mobile, telecoms, e-commerce platforms, the sharing economy, airlines, and so on. So we got some good feedback from that. But on the banking side, for example, the Know Your Customer rules don't necessarily encourage online identification across borders, so we need to look at that. And there's other things being developed in the cross-border taxation and customs environment. The work going on now to establish the possibility of a single person setting up as a limited company, limited liability. So all that needs to be taken on board. So, as I said earlier, this is work in progress, but common expression, we're going in the right direction, I think. So, this is what one might call a European Commission-centric view of the world, because we're at the centre of it. And so you've got the different impacts, inputs and outputs around there. These will be made available, I'm sure. I apologise for some of the acronyms. CEF I've mentioned. ENISA, you'll know, is a European... forgotten. Never mind. It deals with Network Information Security Agency. Got it.
Again, everybody?
Stuff, yeah.
Yes. So it's difficult not to, obviously, with data protection issues.
An important one to note probably is LSPs, Neil.
Oh, large-scale pilots such as Stork, eCodex, which is the legal stuff. There's eHealth, there's eProcurement. There's quite a few.
eSense.
And these are what are termed as building blocks. So they're developing the use cases. But the interesting thing about eID is it's a building block in its own right, but it's also a platform for all the others to build on, because eID cross-border in itself is really an enabler. And I mean, I see in the future, maybe Stork 2 will contribute towards this, is that it would enable commercial, I don't want to use the word exploitation, but commercial innovation around the ability to find and verify attributes on top of the standard minimum data set for identity in a way that will benefit both the user and make life a lot more simple in terms of maybe applying for jobs, all sorts of things.
So Neil's mentioned some interesting concepts there. He also mentioned that I'm involved in the expert group and the technical subgroup. A lot of what I'm going to talk about now sort of crosses over both of those groups. The expert groups talk about the regulation in general as well as the detail, but the technical subgroup was set up specifically to talk about the technical interoperability aspects. And I think that's really important to talk about because of some of the concepts that Neil touched upon there, things like mutual recognition. To be able to do that, you need another thing that he mentioned, which is technology, to be technology neutral, so that we can actually communicate between these different federations. I mean, you saw earlier where Pete demonstrated what we're trying to do in the UK for our Federation of Identity, just for UK citizens. You imagine across all the other 28 member states, there are lots of other things going on. Some of them already have, as Neil said, established eID systems. In some cases, more than one in a particular member state, a different means of identifying yourself online right now. Others are starting from scratch. But what we're not saying in the regulation is, dear friend, colleague, member state, this is exactly how you must provide eID to your citizens. What we're saying is, this is how we're going to interoperate between those different systems, giving the member state freedom to act as they will. So we've got that expert group, which Neil articulated really well there, and we're trying to resolve the implementing acts. One part of that, an important part that we're trying to do right now, is technical interoperability. Because we appreciate there are all these different ways of verifying your identity and proving your identity online in the different member states, what we're not concerned is, as I said, changing that per se. What we're looking at is how we can communicate between them successfully. Because, as Neil mentioned, if I've got a level 3 identity in the UK, and I want to express that and access a service in Germany that requires level 3 according to or substantial as it would be in the regulation, then to be able to express that, I need some means of understanding on both sides of the fence what that level means. And that's part of the technical interoperability, so looking at levels of assurance and coming up with a common standard that everybody can map their services to. So that's part of it at that level. But there's also the deep technological part of things, is how do we actually build this into federation? Because that's what it amounts to, because we're trying to get different member states to communicate to each other, but on a single platform effectively. and to do that successfully. Now, so why is all this very, very important? I'm talking about this as I go on, but some of the key concepts are things like creating a common language so that we can understand between these different schemes and different member states how we express and assert identity. And that means looking at the way we describe metadata at the very low level. It means how we understand which attributes are required and how we can communicate them. It means how we express the levels of assurance, and as I mentioned, having common standards for that. And that brings down the barriers for this interoperability framework and allows us to create this technology across the piece. Now, one of the reasons why I pointed at LSPs in the diagram Neil had is because one of the LSPs is Stork. And some of you in the room are very aware of Stork and Stork 2 as it's moved on to. Stork has appeared before the regulation and started to look at how we can interoperate these different eID schemes at an early point. The regulation has come about while that's been going on, has overtaken it in a way and has now become law. But Stork's still there and has done some practical work in this space. So Digit, who are one of the other directorates within the Commission, have the responsibility of sustainability for that platform. So what we're doing is we're talking to them actively as well about what practically can we do and what can we learn from that experience. And quite a lot is the answer. So what are we actually doing? Well, I mentioned we're looking at levels of assurance. That's already been drafted and that's gone through the expert group, and I think we've got very close to where we need to be with that. Minimum data set's an interesting one. When you talk to different member states, the minimum data set talks about the attributes that you need to be able to identify an individual and to do that uniquely. And the regulation touches on that, but it says, okay, we need an implementing act to figure out exactly what that does. In the UK, we have ideas about what that means. In the UK, we use, for example, your verified name and address data and your date of birth and things like that. In other member states, they just use identifiers, or they might just use your date of birth, your place of birth, plus your name. And there's all different variants across the piece. So what we've done is we've come up with a minimum data set which allows us to express in a common way, using a common language, that metadata, but not to enforce on individual member states that they have to send everything. So there are some mandatory elements in that, but very, very few. Things like your verified name, and the rest of it is optional, and it's what's available in the member state. And that, the more you can express, the more you can interact with services in different member states. An important part of this as well is governance. So how do we, and that's governance not just on a policy level, but with the architecture. Because we're looking at making changes to architectures, that's something that has to be acceptable to all member states, we have to very carefully look at that. And I mentioned, for example, Stork has already done some work in the cross-border space and already has technologies developed that can do that. What we're looking at now is how we can actually improve upon that and build something that can be built upon for everybody, for each member state to implement. And that means that looking at the security aspects and looking at the deep technical aspects of how we build a profile to do that. And that's something that we're doing in the technology subgroup right now. Hopefully we'll have that resolved early in the new year. Thank you very much.
Fantastic. So we've got a few minutes. Coffee's running a little bit late, so we've got a few minutes for questions for Adam and Neil. Start that. We've got a microphone. Well, you've got a microphone. I haven't got a microphone anymore. But we'll have to pass that around between us.
The interoperability challenge is significant, and I think I've got a question for both guys to answer. The history of European activity with IT has been coloured a little bit by perhaps less than a harmonious relationship with the manufacturers of browsers and operating systems and the way that they implement those things. As somebody who's got to make all this work, browsers play a critical part in this. Has there been any dialogue with our friends across the Atlantic, and if so, what?
Okay. You want to pick that one up, or should I? As far as browsers are concerned, what we're talking about here is not browser dependent. In fact, it's not even device dependent necessarily. When we talk about technical interoperability, it's much more conceptual than that in many ways. What we're talking about is how we transfer data, how we understand data, how we can build interoperability at the systems level. What happens within individual member states is entirely out of scope for what we're talking about here. This is about how we communicate and express identity between member states in a cross-border sense. There is nothing within this that is browser dependent or technology dependent.
Somebody's got to make it work at the end of the day, and these platforms are the things that we've got to make it work on.
I agree, Alan, absolutely. But what we're not talking about here is harmonisation, as Neil rightly said earlier. What we're talking about here is building outcome-based standards for much of this, so that we can implement systems that follow the interoperability framework. What we're not doing is specifying individuals' technologies.
But just to add on the non-technical side, obviously we're aware that despite the diagram, the European Union is not the centre of the world, and we follow fairly closely what NIST is doing on the NSTIC programme, and we have exchanged information, and guys from NIST like Jeremy Grant have come over and discussed, because what we want to aim for probably at the end of the day is something not too dissimilar that is not going to be too difficult to get to interoperate. So certainly at the conceptual level we are kind of working alongside.
And we have got somebody from the other side of the Atlantic, from Chile, who will be able to
Mr. Bradley.
comment on that in the next panel session. So. Oh, and here he is.
Having some experience with browser vendors, governments are not a motivating factor for them. In fact, they're sort of insignificant in the great scheme of things. On the upside, there are good commercial reasons to do proof of possession mechanism. So there is a new standard that we're working on at the IETF called token binding, which Google and Microsoft are contributing to, which will allow for some of the things that Stork has wanted and been told no repeatedly around doing proof of possession tokens that may be possible using the new standard. My question is, there seems to be a bit of an impedance mismatch between some of the European states, which are the identity providers, and the UK, which is using commercial identity providers. So one has to wonder, in the European regulation where identity providers can't charge governments, or for cross-border, so using a UK provided credential where it's from a commercial provider, how does one imagine using that at an Italian government service, etc.? Is there a plan for a UK international gateway? Are those credentials going to be accepted directly? So in some ways it might be easier for I was going to say it might be easier for a German eID card to be used at the UK, but that just seems so silly. Thinking about the technical issues, but you would never get a terminal certificate, so forget it. But in some cases, it might be more controllable, at least for some government eID systems to be accepted by other governments. How is it imagined to work where you have this interplay of private sector identity providers?
Well, the regulation makes it quite clear that what we're talking about electronic identification means either issued by or under the control of a member state. So in the UK's position, and it's not alone, because there are different variations on this in other countries, like in Sweden, Swedbank issues cards, and in Denmark and so on. The point is that it's the words under the control of and what that means. So in the UK, the private sector identity providers are obtained through procurement, and they will have to operate to rules and procedures and standards that the Government Digital Office set for them. and there will no doubt be attendant control and audit measures and all the rest of it. So because any scheme that's notified has to state the level of assurance and to be transparent about how it operates, who the responsible authorities are, etc., all to do with this notification procedure, all the information is there, that will have the same status as an identification means issued in another member state direct from the Chancery or whatever government department. So I think there's no difference whatsoever from that point of view. On the technical side of how that works, well, I think it's it's an online transaction as I see it, and quite how service providers handle that in different countries will be for them to decide. They will have risk assured their service and decided what level of assurance they want, and if the offered electronic identification means meets that requirement, and maybe we'll have a trusted list. Well, we haven't worked this out yet. I'll say it's work in progress. How do they know about this particular EID means? Well, we will find a way that works for that. I don't know if you want to add anything on that side.
All I would add, Neil, is that you were talking largely there about accessing public services. If that identity was used to access a private sector service provider, that might be a different question altogether. And the question of, is there a charge there, does come into play. That, as Neil says, though, has not yet been resolved. There needs to be this commercial model that makes that happen. But there is a possibility there that, yes, there could be some charge for authentication in that respect. Absolutely right about UK service identity providers. They are providing identity for access to government services under a framework that is operated by Cabinet Office on behalf of Her Majesty's Government. So, yes, it is within control according to the regulation of the UK.
Just a question, as the previous gentleman. Just wondering about the main provision of the regulation is the mutual recognition of the identity service provider of each member state. So there, as in the UK, there can be numerous, a large number of those providers. If it's mutual recognition and it's at the level of that service provider within each member state, it's not just the particular government department that has the control, as you said, of that service provider. Is that not, that can be a long list, and each one will have to mutually recognise the other service provider, because any citizen can present themselves looking for a service in another member state. Don't you end up with a large number of possible interfaces, connections, mutual recognitions, or whatever term you want to call it, by the fact that excuse me, the identity is provided that by provider, not singly by the government? There has to be means of brokering that identity within a circle of trust, because otherwise, you know, and it's just going back, as you said, the large-scale pilots are the arena by which these use cases are being tested, and the eIDAS regulation is seen as a major building block of that. To date, you know, the number of transactions are quite low, you know, and it's a lot of effort for these cross-border services where member states like the UK are grappling with the national ID systems for their own service provisions. And I just wonder if the eIDAS regulation means that this mutual recognition is an X factor of the number of providers within each member state, then it will be the UK government going to Experian, contracting them not to provide just an identity assurance tool for the UK, but for every other one that might be presented from other member states. And how is that going to be resolved?
Yes, there are a large number of possibilities when you think about it conceptually of within each member state there might be multiple identity provider options for citizens. That's absolutely true. There are some things to note here though, that the eID schemes will only be used for cross-border transactions if they're notified by a member state. So that's the first thing to bear in mind. So there may be many schemes within a member state, but that doesn't mean that member state has to notify all of them. So that's one thing to bear in mind. In the case of the UK, where we deliberately provide choice, there will always be multiple identity providers, because we ask all of our identity providers to provide multiple levels of assurance. And we will probably end up notifying the whole scheme because of that. In that case, if I've got a relationship with my identity with Experian, I've got a relationship with them because I'm a UK citizen. So yes, I might use that identity to access services outside of the UK under the regulation, but I'm using it as a UK citizen. And that should be my right as part of the European Union to be able to freely access services in other member states. Why would I not want that to happen as HMG? So yes, there is complexity in this, but yes, I think it's good that the citizen gets the opportunity to do as they wish. I think we also need to bear in mind that at the technology level, we appreciate that there will be multiple schemes within member states. That's just reality. If we look at Germany, there may be many, there could be hundreds, we don't know yet, simply because they have different means of issuing ID in different municipalities. So who knows how many they will have, but that's for member states to resolve. But the individual, the citizen, needs to be able to drive that process. And the technologies we're talking about provide the ability for you to do that within your own member state. So the interoperability framework and the technologies behind it don't provide harmonisation for that. What they do is they provide a means, a gateway, if you like, for allowing citizens to access what they would normally do within their own member state. So in the UK, I would normally go to the Verify hub and I would find my identity provider. If I'm trying to access a Spanish service, that's exactly what I'd do as well. I'd just be sent to where I normally go to log into a system. And hopefully in that way, citizens will have a similar experience in a cross-border sense as they will do in a local sense.